Hello, today we're going to discuss about the revised corporation code, specifically the dissolution of the corporation and the investigations, offenses, and penalties. So without further ado, we'll begin. Title 14, Dissolution. So to begin, let us first define what is dissolution first. So, dissolution is the termination of the legal life of a corporation. It ceases to be a juridical person and consequently can no longer continue transacting its business. However, just like in a partnership, it still has a corporate existence for the purpose of winding up or liquidation for a period of 3 years, which we'll talk about in a later section. So first section, section 133, methods of dissolution. A corporation essentially exists perpetually unless its existence is fixed on its articles of incorporation. Despite this perpetual existence, the Revised Corporation Code allows two methods that a corporation may dissolve its existence, namely voluntary and involuntary. In voluntary dissolution, there are generally two ways: by filing an application for dissolution with the SEC or by amending the Articles of Incorporation to shorten the corporate term. Let's start first with the first one I mentioned, by filing an application for dissolution with the SEC. This basically has two methods also, wherein there are no creditors are affected and where creditors are affected. The first one is tackled by Section 134 and the latter by Section 135. So in a voluntary dissolution where no creditors are affected, it is a dissolution of a corporation that does not prejudice the rights of any creditor having a claim against it. The dissolution may be effected by a majority vote of the Board of Directors or Trustees, and this majority vote must be ratified at least by the majority of the outstanding capital stockholders, or majority of the members,
The procedure for this should be done in a meeting.
with each shareholder member, whether entitled to vote or not, be notified 20 days prior, either by mail or any means authorized in the bylaws, in the manner provided in Section 50, which is the place and time of meetings of shareholders or members. And it should be provided that the purpose of the meeting is for the dissolution of the corporation. Also, the same notice should also be published in a newspaper containing the time, place, and object of the meeting, prior to the date of the meeting in the place where the principal office is located, or if there is none, in a newspaper of general circulation in the Philippines. This is necessary for the protection of the creditors. After the majority vote of the BOD or BOT is ratified, they may now file for a verified request for dissolution with the SEC, and this should state the reason for the dissolution, the form, manner, and time when the notices were given, names of the stockholders and directors or members and trustees who approved the dissolution, the date, place, and time of the meeting in which the vote was made, and lastly the details of the publication. After that, the corporation shall submit the following to the Commission or SEC: a copy of the resolution authorizing the dissolution, certified by the majority of the Board of Directors or Trustees, and countersigned by the Secretary of the Corporation; proof of publication; favorable recommendation from the appropriate regulatory agency when necessary. So this is applicable to banks, quasi-banks, and other financial institutions. So within 15 days from receipt of the verified request for dissolution, and in the absence of any withdrawal within said period, the Commission shall approve the request and issue the certificate of dissolution. The dissolution shall take effect only upon the issuance by the Commission of a certificate of dissolution. So just like how a certificate of incorporation brings to life a corporation, the issuance of a certificate of dissolution. And next will be the voluntary dissolution where creditors are affected. So instead of a verified request for dissolution. In here, a verified petition for dissolution is needed to be filed in the SEC. It too shall need majority votes of the Board of Directors or Trustees, verified by the President, Secretary, or one of its directors or trustees, and also ratified by at least two-thirds of the outstanding capital stockholders or members. Take note of the difference, the amount of stockholders or members that needs to ratify between when creditors are affected or not. So when creditors are affected, needs more percentage of the outstanding capital stockholders or members, two-thirds. The petition shall likewise state the reason for the dissolution, the form, manner, and time when the notices were given, and lastly the date, place, and time of the meeting in which the vote was paid. The corporation shall submit to the SEC the following: a copy of the resolution authorizing the dissolution, certified by a majority of the Board of Directors or Trustees, and countersigned by the Secretary of the Corporation. And lastly, a list of all its creditors. After that, the SSC will then give an order if petition is sufficient in form and substance, which will be published at least once a week for 3 consecutive weeks in a newspaper of general circulation published in the municipality or city where the principal office of the corporation is situated. Or if there is no such newspaper, then in a newspaper of general circulation in the Philippines, and a similar copy shall be posted for 3 consecutive weeks in 3 public places in such municipality or city, the purpose of which is to allow for objections to be filed to the dissolution. Now, if there are people who will object to the dissolution, these objections must be given at not less than 30 days nor more than 60 days from the time the order was issued to the SEC. After 5 days from the time to file objections has expired, SEC will now hear the petition and will decide on any issue if there are objections. A hearing will occur if no objections are present and/or sufficient to stop the dissolution, and the material of allegations of the petition are true. Then the SEC will now dissolve the corporation and directing such disposition of its assets as justice requires, and may appoint a receiver to collect such assets and pay the debts of the corporation. The dissolution shall take effect only upon the issuance by the corporation of a certificate of dissolution. So the other method of voluntary dissolution is by amending the Articles of Incorporation to shorten the corporate term. A copy of the amended Articles of Incorporation is submitted to the SEC. The dissolution will take effect automatically after the expiration of the shortened term or upon expiration of corporate term, which is the day following the last day of the corporate term stated in the Articles of Incorporation. In this case, the issuance of a certificate of dissolution is not needed, since it is automatic. What happens if a corporation does not want to push through with its request or petition for dissolution? Section 137 tackles that problem. A withdrawal of the request for dissolution shall be made in writing, duly verified by an incorporator, director, trustee, shareholder, or member, and signed by the same number of incorporators, directors, trustees, shareholders, or members who voted for the dissolution. Upon receipt of a withdrawal of request for dissolution, the SSC shall withhold action on the request for dissolution, and shall, after investigation, firstly, make a pronouncement that the request for dissolution is deemed withdrawn. Second, direct a joint meeting of the BOD or BOT and the stockholders or members for the purpose of ascertaining whether to proceed with the dissolution. And lastly, issue such other orders as it may deem appropriate. A withdrawal of the request for dissolution is essentially the same with that of the withdrawal of a petition for dissolution. The latter shall be verified and filed prior to the publication of the order setting the deadline for filing objections for the petition. Involuntary dissolution. It is practically where a corporation dissolves against its own will, and where the corporation itself did not initiate its own dissolution. There are multiple ways in which a corporation will be dissolved involuntarily, some of which are stated in Section 138. A corporation will be dissolved by the SEC, motu proprio, and upon filing of a verified complaint by an interested party. And now, the following may be the grounds for dissolution of the corporation. First will be non-use of corporate charter as provided under Section 21 of this code. Recall that Section 21 contains that if a corporation does not formally organize and commences business within 5 years from the date of incorporation, so wala. Second will be continuous in operation of a corporation as provided under Section 21 of this code. So to reiterate Section 21, if a corporation has commenced its business, but subsequently becomes inoperative for a period of at least 5 consecutive years. The third ground would be upon receipt of a lawful court order dissolving the corporation. So if may mukaso sa corporation ipa-dissolve. The fourth ground will be upon finding by a final judgment that the corporation procured its incorporation through fraud. So if fraudulent ang pag-incorporate. The fifth ground will be upon finding by final judgment that the corporation firstly was created for the purpose of committing, concealing, or aiding the commission of securities violations, smuggling, tax evasion, money laundering, or graft and corrupt practices. Second, committed or aided in the commission of securities violations, smuggling, tax evasion, money laundering, or graft and corrupt practices, and its stockholders need. And lastly, repeatedly and knowing tolerated the commission of graft and corrupt practices or other fraudulent or illegal acts by its directors, trustees, officers, or employees. If a corporation is dissolved under the pursuance in the grounds set forth in subparagraph E, the assets of the corporation, after payment of its liabilities, shall, upon petition of the SEC with the appropriate court, be forfeited in favor of the national government. So it is reverted to the national government since its practices were illegal. Such forfeiture shall be without prejudice to the rights of innocent stockholders and employees for services rendered. So labot ang katong in good faith na stockholders and employees, and to the application of other penalty or sanction under this code or other laws. Section 139. Corporate liquidation. In partnership, we have distinguished between dissolution and liquidation, in which liquidation occurs after dissolution. Take note that this is liquidation with a solvent corporation, since liquidation of an insolvent corporation is under the Financial Rehabilitation and Insolvency Act, or FREA. And also, this section expressly states that this excludes banks, since it is covered in the new Central Bank Act and Philippine Deposit Insurance Corporation Charter. After dissolution by any means, a corporation continues to be a body corporate for 30 years after the effective date of dissolution for the purpose of prosecuting and defending suits by or against it, and enabling it to settle and close its affairs, dispose of and convey its property, and distribute its assets, but not for the purpose of continuing the business for which it was established. Another method for liquidation may be through the conveyance of the properties of the corporation to trustees for the benefit of its stockholders, members, creditors, and other persons in interest, after which the interests which the corporation had in the properties will be terminated and vested upon the trustees, subject to the beneficial interest of the stockholders, members, creditors, and other persons in interest. Section 139 also expressly states that any asset distributable to any creditor or stockholder or member who is unknown or cannot be found shall be escheated in favor of the national government, subject to provisions of the rules of distribution and plan of distribution of assets. By escheated, meaning it is reverted to, and also it is a general rule that the distribution of assets shall be first applied to its debts and liabilities, and only upon its balance would it be for the distribution to its shareholders or members. The next title that we will be discussing is Title 16, Investigations, Offenses, and Penalties. One of the rationales for the revision of the Corporation Code was to bring more power and authority for the Securities and Exchange Commission. Before it was revised, there were a lot of issues regarding corporations, specifically fraudulent practices, graft, and corruption, and mostly the SEC was not able to act upon it. In this title, we could realize the nature and extent of this power and authority. We could see the authority of the SEC here because it states that not only the violation from the Corporation Code, but also its rulings, regulations, and orders would render them to investigate. So that means a corporation will not only have to adhere to the revised Corporation Code, but also any issuances by the SEC. After such investigations, the SEC may inform the public or parties concerned of their findings, orders, opinions, advisories, or information gathered. This will be limited to the Data Privacy Act and other relevant laws. If such findings will violate the rights of the parties concerned or the corporation. But before any publication of the findings, the SEC will only have to give reasonable notice to the necessary regulatory agency. Section 155, Administration of Oath, Subpoena of Witness and Documents. In this section, we could see the power of the SEC. Through its designated officer, they can administer oaths and affirmations, just like a notary public, issue subpoena and subpoena to tecum. So what is a subpoena and subpoena to tecum? In a subpoena, they can compel you to appear before them. Meanwhile, subpoena to tecum, they can compel you to bring forth documents stated on the subpoena to them. In a later section, we will know what happens if one doesn't comply with the subpoena. The SEC could also take your testimony necessary for the further investigation, which is also crucial if it may lead to a court proceeding. Section 156, Cease and Desist Orders. This is a continuation of their powers, in which the SEC could also issue cease and desist orders, which means the SEC can compel a corporation to stop its operations and its continuation on the reasonable basis that they have violated a corporation code, ruling, regulation, or order. Not only that, but they could also issue a cease and desist order ex parte. This is like the cease and desist order, but the difference is that this is in favor of one party. So if a corporation is issued one, they are unfavored, being the one who is compelled to stop without prior notice or hearing of their side. This may be unfavorable or unfair for them, and violates their right of notice and right to be heard. But this is with justification that they are practicing fraudulent acts and or acts causing significant, imminent, and irreparable danger or injury to the public safety or welfare. So it gives importance and protects the public safety or welfare. But this cease and desist order is only limited to a maximum of 20 days, so as not to abuse it, and without prejudice to it being made permanent, which occurs if due notice and hearing is done. So this means that the cease and desist order may become permanent after due notice and hearing, proving that a corporation is practicing fraud or causing harm to the public. After such investigation and issuance of the cease and desist order, If the SEC accumulates the proper evidences, they may litigate administratively, which is covered in a later section, and/or if they have deemed a corporation to be criminally liable, they will pass the evidences to the Department of Justice, or DOJ, since this is not within the jurisdiction of the SEC. In other words, a corporation will be charged administratively or criminally, or even both. Section 157. Contempt. Earlier I said what will happen if one didn't comply with the subpoena. So to answer that, the SEC has contempt powers to counter non-compliance, not only for the subpoena but also SEC order and decision, will make one be held in contempt. Being held in contempt means that one has to pay 30,000 pesos and 1,000 pesos per day if one acts in defiance with the SEC. Section 158. Administrative Sanctions. To expound earlier on being litigated administratively, this means that if one is found to be in violation to the Corporation Code, SEC rules, regulation, and order, then the SEC will be the one to judge and impose the penalty to the violator, taking into consideration the extent of participation, nature, effects, frequency, and seriousness of the violation. First, imposition of a fine ranging from 5,000 pesos to 2 million pesos, and not more than 1,000 pesos for each day of continuing violation, but in no case to exceed 2 million pesos. Second, issuance of a permanent cease and desist order. Third, suspension or revocation of the certificate of incorporation. And lastly, the dissolution of the corporation and forfeiture of its assets under the conditions in Title 14 of this code, which is the dissolution. So this is basically a involuntary dissolution. In the next following sections 159 to 168, are prohibited acts and their respective penalty. In here I will enumerate them. Section 159. Unauthorized use of corporate name. Since one cannot use a corporate name that is already existing, otherwise it would be the unauthorized use of a corporate name. The penalty will be a fine ranging from 10,000 pesos to 200,000 pesos. Next will be Section 160, violation of disqualification provision. In Section 26 of this code, states that the disqualification of a director, trustee, or officer and its causes therein. Now, if such director, trustee, or officer has full knowledge of his or her disqualification and still continues to hold his position or hide such facts, then he or she is in violation of this section. The penalty will be a fine ranging from 10,000 pesos to 200,000 pesos at the discretion of the court, and shall be permanently disqualified from being a director, trustee, or officer of any corporation. If his or her violation of this provision is injurious or detrimental to the public, the penalty shall be a fine ranging from 20,000 pesos to 400,000 pesos. So basically double. Section 161. Violation of duty to maintain records to allow their inspection or reproduction. The unjustified failure or refusal by the corporation or by those responsible for keeping and maintaining corporate records to comply with Sections 45, which is the adoption of bylaws, Section 73, which is the books of the corporation to be kept at the principal office, Section 92, list of members and proxies and place of meetings, Section 128, records in lieu of meeting for OPC, Section 177, for reportorial requirements of corporation. So basically documents and any important records for the corporation, and other pertinent rules and provisions of this code on inspection and production of records shall be punished with a fine ranging from 10,000 pesos to 200,000 pesos. at the discretion of the court, and if the violation is injurious or detrimental to the public, the penalty is a fine ranging from 20,000 pesos to 400,000 pesos. So same with the previous section, doubled. Section 168. Rule for certification of incomplete, inaccurate, false, or misleading statements or reports. Any person who willfully certifies a report required under this code, knowing that the same contains incomplete, inaccurate, false, or misleading information or statements, shall be punished with a fine ranging from 20,000 pesos to 200,000 pesos. When it is injurious or detrimental to the public, it is a fine ranging from 40,000 pesos to 400,000 pesos. Section 163. Independent Auditor Collusion. An independent auditor who, in collusion with the corporation's directors or representatives, certifies the corporation's financial statements despite its completeness or inaccuracy, its failure to give a fair and accurate presentation of the corporation's conditions, or despite containing false or misleading statements, shall be punished with a fine ranging from 80,000 pesos to 500,000 pesos. So it is more serious now. And if the violation is injurious or detrimental, or when the statement or report is certified to be fraudulent, then the fine will be ranging from 100,000 pesos to 600,000 pesos. Section 164. Obtaining corporate registration through fraud. Those responsible for the formation of a corporation through fraud who assisted directly or indirectly therein shall be punished with a fine ranging from 200,000 pesos to 2 million pesos. When the violation is injurious or detrimental to the public, a fine ranging from 400 pesos to 5 million pesos. Section 165. Fraudulent conduct of business. A corporation that conducts its business through fraud shall be punished with a fine ranging from 200,000 pesos to 2 million pesos. When it is injurious or detrimental to the public, it is a fine ranging from 400,000 pesos to 5 million pesos. Section 166. Acting as intermediaries for graft and corrupt practices. A corporation used for fraud or for committing or concealing graft and corrupt practices are defined under pertinent statutes, shall be liable for the fine ranging from 100,000 pesos to 5 million pesos. When there is a finding that any of its directors, officers, employees, agents, or representatives are engaged in graft and corrupt practices, the corruption's failure to install safeguards for the transparent and lawful delivery of services, policies, codes of ethics, and procedures against graft and corruption, shall be prima facie evidence of corporate liability under this section, such as presume that they have corporate liability. Section 167. Engaging intermediaries for graft and corrupt practices. A corporation that appoints an intermediary who engages in graft and corrupt practices for the corporation's benefit or interest shall be punished with a fine ranging from 100,000 pesos to 1 million pesos. Section 168. Tolerating graft and corrupt practices. A director, trustee, or officer who knowingly fails to sanction, report, or file the appropriate action with the proper agencies allows or tolerates the graft and corrupt practices or fraudulent acts committed by a corporation directors, trustees, officers, or employees shall be punished with a fine ranging from 500,000 pesos to 1 million pesos. Section 169. Retaliation with whistleblowers. So first, let's define what a whistleblower is. A whistleblower refers to any person who provides truthful information relating to the commission or possible commission of any offense or violation under this code. So, any person who knowingly and with intent to retaliate commit acts detrimental to his whistleblower, such as interfering with the lawful employment or livelihood of the whistleblower, shall at the discretion of the court be punished with a fine ranging from 100,000 pesos to 1 million pesos. Section 170. Other violations of the Code. Violations of any of the other provisions of this Code or its amendments, not otherwise specifically penalized therein, shall be punished by a fine not less than 10,000 pesos, but not more than 1 million pesos. The violation committed by the corporation, the same may, after notice and hearing, be dissolved in appropriate proceedings before the Commission, provided that such dissolution shall not preclude the institution of appropriate action against the director, trustee, or officer of the corporation responsible for said violation, provided further that nothing in this section shall be construed to repeal the other causes for dissolution of a corporation provided in this code. Liability for any foregoing offenses shall be separate from any other administrative, civil, or criminal liability under this code and other laws. Section 171. Liability of directors, trustees, officers, or other employees. If the offender is a corporation, the penalty may, at the discretion of the court, be imposed upon such corporation and/or upon its directors, trustees, stockholders, members, officers, or employees responsible for the violation or indispensable to its commission. Since a corporation is a artificial being or artificial person, the people that it is made of will be the one who will be penalized.